There.
Okay, good morning.
Good morning.
Morning.
I'm Judge Eisnagel. We have on the panel today Judge Traver and Judge Wallace. This is our second and final case for today, I believe, 19-18-36, Cloak versus Cloak. If I'm mispronouncing the name, please correct me. We will give the appellant 5 minutes in rebuttal unless you let me know differently.
No, 5 minutes is what I was going to ask for.
5 minutes, okay.
Yep. Thank you.
And so you'll have 5 minutes in rebuttal. And with that, counsel, whenever you're ready, you can begin.
Good morning. May it please the court, counsel. My name is Michael Kelton, and I represent Michael Clokey. He's the personal representative of the estate of Margaret Clokey. When the case first started, he was the power of attorney for Margaret Clokey. She passed away during the case, while the case was pending. As you know, we are here because there was a claim filed in the trial court to set aside and rescind a deed due to undue influence and due to lack of mental capacity to have the actual capacity to sign the deed. The family that's involved here, because everybody's last name is Clokey, I'm going to refer, it's not in disrespect, I'm going to refer to the children by their first names. It's just easier. And Margaret Clokey will be Mrs. Clokey. Mrs. Clokey was married to Carl Clokey. He predeceased her. She had 4 children: Michael Clokey, Sandra Clokey, Donald Clokey, and Susan Clokey. Susan Clokey had 2 children. They were adopted by Margaret Clokey. And so where they were nephews and nieces of the older siblings, they all became siblings. Sometimes you'll see in the case they're referred to as my niece. Sometimes they're referred to as my sister. Sometimes people refer to as uncles. But on a legal basis, everybody is siblings for all intents and purposes. We're here today because the trial court found, after all the evidence, that there's the appellee met their burden and rebutted the presumption. And I'm sure this court's aware that when you have a claim for undue influence, there is a rebuttable presumption. And once the person who's filing the claim for undue influence establishes that the beneficiary of a deed was the procuring cause of the deed, they were a beneficiary of it, and they had a confidential relationship. In this case, the trial court correctly found all those things. And I don't think the appellees necessarily dispute that. The deed in question was one that Donald Clokey procured for his mother, Margaret Clokey. At the time, she was in an assisted living facility. He had been estranged from the family for 5 years. When his father passed away, Carl, Margaret Clokey was moved into an assisted living facility. At that time, Donald Clokey showed back up again and began having some involvement in Mrs. Clokey's life. Prior to that, he had been estranged for 5 years. Mrs. Clokey had prior wills up until this point. Both of them had prior wills. There was a will from 2014 that did not name Donald as a beneficiary. There was a will from 2016 that did not name Donald as a beneficiary. And then there was a codicil that Mrs. Clokey signed that also did not change to name Donald as a beneficiary. He was essentially estranged from the family and he was left out from all estate planning purposes. After his father died, he then came back around. Like I said, Mrs. Clokey was moved into an assisted living facility because she could not live by herself. Her mental condition was slipping. She had been diagnosed with dementia. She was unable to live by herself. The whole family knew that there was a concern. She was moved into an assisted living facility. While she was there, she did not want to be there. She wanted to go home. She didn't understand why she was there. She was depressed. She was sad. She was forgetful. She would forget that her husband had previously died or recently died. She would forget how many children she had. She would forget where she was. She made claims at times that her son owned the facility. She was slipping on a mental state, very much so. Everybody had to take care of her.
It certainly seems that there was at least evidence from which the trial court could have found lack of capacity or undue influence here. But your argument is that the evidence was insufficient, at least the way I read it in your brief, it seems like the primary thrust of your argument is that that you say in the brief that the trial court applied the correct presumption, but that the evidence was insufficient to rebut the presumption.
Correct, Your Honor, and I appreciate you bringing me.
Why that is the case here, given what there at least was some conflicting evidence. Do you agree?
I believe the evidence showed, like I said, the duty becomes the duty shifts, the burden shifting, and then the burden then becomes upon the beneficiary of the deed to provide some reasonable explanation as to why she changed her estate plan, as to why she transferred the property. And the Carpenter case from the Supreme Court said it really depends on the fact of the case, what that reasonable explanation is. Sometimes it can be, why did the donor change their longstanding estate plan? Sometimes the explanation requires, why did the donor give away their only piece of property? And so it was fact dependent. Here we have a situation where the court correctly found that the burden shifted to Donald, but what it did, where it kind of blended the standard somewhat, is it jumped right to the burden of, but where's the undue influence? Where's the evidence of that? And it didn't, it used the lack of evidence of actual direct undue influence as the reason why they rebutted the presumption. And I think once the presumption arises and the beneficiary of that will, of that deed or that will,
didn't the trial court point to the actually say that that a reasonable explanation was offered?
The trial court in their judgment said, based on the testimony, it found a reasonable explanation was provided, but it didn't specify what that reasonable explanation was. It went on. It was kind of unclear.
Counsel, what wasn't it? The trial court attached a lot of significance to the testimony of the Johns, the couple. It seemed to rely obviously you have family members testifying and maybe with some type of underlying vested interest, but the Johns testimony and longtime friends of theirs who have maintained contact with the couple, and there was pretty extensive testimony about arguably the influence of Mr. Clokey on his wife, and the negative relationship between Mr. Clokey and Donald. Isn't that correct?
That's correct. The testimony of the Johnses, I believe, is important and it's relevant once the burden then shifts back to my client. Their testimony simply was, we were not aware of any coercion. We did not see any evidence of undue influence. But what is required once the burden shifts to the appellee here, what's required is a reasonable explanation as to why this particular act was done.
Well, isn't the reasonable explanation just basically a equaling or a equalizing of the assets that was going to be coming from the estate, and also a concern from Mrs. Clokey as far as the threat, or I guess the understanding that Michael intended or wanted to put the property up for sale, and she didn't want that.
The only evidence of that was Donald Clokey's testimony. Nobody else ever testified they ever heard Margaret ever complain about Michael, ever show.
Counsel, doesn't that defeat your argument on some level by itself? Why is his testimony not competent?
It's not that it wasn't competent, but he certainly has a bias, and so it goes to weight. It goes to credibility.
Isn't that for the trial court to decide, not an appellate court?
It is. That would be whether, granted, I think if that truly is the explanation, that she was trying to protect this property from Michael, she didn't want him to sell it. There were a number of different things. And as this court pointed out in Thomas v. Lampkin, there are a number of different things that she could have done if she truly was in fear, and we don't necessarily think that was the case, but she could have changed her will. She could have done a life estate deed. There was no reason to do an outright deed to Donald, and not only just Donald, but Lynette. Lynette's also on this deed. If she's simply trying to protect it from Michael, she can change her will, which Donald said he tried, and no attorney would do it because of her capacity issues. She could remove him as power of attorney, which she made no effort of doing. She could have done a life estate deed where she gave it to Donald and Lynette, the remaining interest of Donald. And there are a number of different things they could have done. What she did, though, by doing this and by the deed being procured, is that she basically destroyed any potential benefit for future Medicaid benefits. And Kobe Finley, the attorney, testified at length. I advise them, when you go and you need assisted living and you need benefits from Medicaid for that, they're looking at your homestead. And if you just give your homestead away, if you transfer it, they're going to count that against your assets, and you're going to then have to spend all that money that you would have had in the house before you get the first dollar from Medicaid. And that's why this was important, because this was so against her self-interest. There was a number of different things. And as a Thomas court.
But counsel, isn't that just a really good reason why the trial court could have not believed the explanation? I mean, that seems like an argument. That seems like an argument that you're saying the trial court should not have believed the explanation, right? Because it doesn't make sense. She would have lost her Medicare.
Well, I think Medicaid. I think the importance of the explanation is, as Thomas V. Lampkin pointed out, if that truly is the explanation, there are so many other things you can do that don't detriment somebody like that. If she wanted Michael or Donald to have the house, she could have changed her will. If she wanted to protect it, she could have put it into a trust. These are all the things that could have happened. Instead, there was just an outright deed for no consideration. That explanation, if that's what the court relied upon, which was Donald's testimony that she was afraid Michael would get the property, which, again, it's nobody said that at all or supported that testimony. But if that's the only explanation, the argument is that's not a reasonable explanation for purposes of rebutting the presumption. It's even, she had put Michael as PR. Michael is the PR of the estate. And so she had a fear of Michael selling the house. It's what we were trying to actually, or what Michael was trying to keep from happening, was the house be sold. He was maintaining the house. So if her concern was that he was going to sell it, then why would she just give it to Donald? Donald testified that she believed she was moving back to the house. He asked,
counsel, just so I understand, your argument is essentially that that the explanation wasn't reasonable because there were better ways that this could have been accomplished.
Yes, there were a number of ways that, like I said, the Thomas court, I believe, said that there are a number of different things that the person, Thomas, the decedent, could have done that didn't leave them a homeless pauper, I think was the terminology they used, where this is her main asset, this is her homestead, this is what allows her to have Medicaid benefits. And if she simply was trying to even out the estate and the distribution, then change the will. Do it with the life estate deed. These things all would have kept the asset there, because as Rachel Clokey, the daughter, testified, she was running out of money. At some point, depending on what her lifespan was, there was a very good possibility they were going to either be applying for Medicaid benefits or have to use the value of that house to help pay for her care.
Mr. Tilton, so kind of an extension of Judge Eisnagel's question, you're also saying there were other ways to transfer the interest. And are you also saying that none of the explanation that the trial judge received was reasonable?
Correct, Your Honor. The trial judge didn't specify what explanation was relying upon. From the testimony at trial and deposition, the best that I could garner is Donald's explanation was she didn't want Michael to have it, and she wanted me to have it. Well, presumably, if anybody transfers property via deed, the idea is they want the other person to have it. So that's not a reasonable explanation why somebody would divert from a long-standing estate plan to their detriment. There's no explanation given anywhere. So I guess to answer your question, just Wallace, yes, the explanations, the only two explanations that are even in the record, which the trial court didn't specifically reference, but I've garnered, are the only explanations Donald gave. It's not reasonable given the detriment, the potential loss of benefits. It's not reasonable because it doesn't take into account any of the other beneficiaries of the estate. There was another beneficiary.
Mr. Kelton, wasn't there record evidence in the trial court that Lynette, I guess the girlfriend, Donald's girlfriend, offered to buy the house from the mother?
If there was evidence of that, or there was testimony, I don't believe that they had any ability to do so. They certainly, as far as I know, there's nothing in the evidence that says, I think Donald testified, I couldn't buy the house. He said, I couldn't actually do it. At one point, he did testify that he wanted to buy it from Donald or from Michael. And Michael said it's not for sale. And again, I don't think Donald had the ability to do it even if he wanted to. So that may have been said. That's the only mention of that. There was nothing that went further along those lines. I have hit my 5. Right. I started at 20. So if I'm into my rebuttal time. Okay. Well, then I'll rest and I'll save my remaining time for rebuttal. Thank you.
Thank you, counsel. All right, counsel for the appellee, whenever you're ready, you can begin.
Yes, if it may please the court, my name is George Travato. I'm representing the defendants in this matter. I think what's important here is a timeline in addition to what the court rendered in its final judgment. What was put in the evidence was that Ms. Clokey did a will with an attorney named Finley in May of 2016. She then followed it up with an amendment in August of 2016. And 2 weeks later, her husband, Carl, had died. At no point in time, even though there's testimony in the record from Rachel, who is the adopted granddaughter of Ms. Clokey, making her her daughter, that she was incapacitated, even though Rachel had said that she was diagnosed with dementia over a year prior to that. So as far as the incapacity or lack of mental capacity to sign any wills, there's evidence from Rachel saying that the Ms. Clokey was diagnosed with dementia, but yet the attorney who wrote the wills the following year in 2016, Ms. Finley, in the amendment, indicated that she was of sound mind, knew what she was doing, headstrong, testified that there was no undue influence as far as she was concerned, and that there was some discussion about whether or not Carl had any influence over Ms. Clokey, Carl being her husband. Right after that, what opposing counsel is go ahead.
Do you agree the presumption applies here? The presumption?
I agree, yes. I was just going to get to that. The one thing is that once the father died, Donald, Michael, Rachel, they all came together at that point. It wasn't like the mother went to the assisted living facility and Donald showed up. In fact, there was a Hurricane Matthew at that time that occurred right after the husband died. And Miss Clokey actually stayed with Donald during that hurricane at the house before she was moved to an assisted living facility. So the evidence in this case failed to show that Margaret lacked any mental capacity at the time the deed was signed. Okay, there's just no evidence at all, no medical records, no testimony, nothing that anyone who witnessed the signing of the deed or knew Ms. Clokey at that time said that at the moment she signed, she was incapacitated. The evidence did show.
You agree that the presumption applied. Tell us what evidence overcame the presumption.
Okay, yes, I agree that the presumption applied because of the closeness and the relationship of the parties. Then the question then becomes, what was a reasonable explanation? Ms. Clokey did not like living at the assisted living facility. That was testified by several witnesses. Ms. Clokey then offered the home to Rachel, who was taking care of all of her affairs, her financial affairs, her personal needs, anything that was required. Rachel was now in charge solely. Donald had no involvement at all. Rachel turned down that offer. Ms. Clokey, wanting to divest herself of the home, then offered it to Donald. Donald at first rejected it because that was back in October of 16. And it wasn't until 6 months later in March of 17 when the deed was actually signed. During that time, the Johns, who the court relied on saying that there was compelling testimony, the Johns had had several visits, many visits actually, and at times weekly visits with Ms. Clokey, discussing the issues about the family as they had done for over 50 years. It wasn't just friendship, it was friendship for over 50 years on a weekly basis. They knew the children since they were born. They knew each other since they were in the Navy, when Carl Clokey was in the Navy. The Johns discussed with her saying, are you sure this is what you want to do? And the Johns testified that yes, she did. This is what she wanted to do, is give the house over. So it was 6 months later, after many visits with the Johns, that Donald then went out, hired a notary to obtain the deed, presented the notary with the deed, with the Johns present. They discussed it. It was executed. Is what she wanted. Nothing in the testimony after.
I think your opposing counsel would argue that that's not enough. I think your opposing counsel has already argued that the desire to transfer the deed isn't enough to overcome the presumption, that there has to be an explanation for why she wanted to transfer the property.
Okay.
Do you agree with that? And whether you do or not, was there evidence to establish, reasonable evidence to establish, or was there evidence that might establish a reasonable explanation for why?
Well, the reasonable explanation was testified in testimony by other witnesses that said that Ms. Johns said that Margaret and Carl, Ms. Clokey and Carl, her husband, would have arguments over and over about excluding Donald from the will. That it was Carl who wanted Donald out of the will because of this loan and this rift that had occurred for over 5 years. But that all of a sudden, everyone was involved once Carl died. And so Ms. Clokey basically wanted to give Donald the house. There was also testimony in there that wasn't discussed where Ms. Clokey said that she wanted to go and stay in her house, although everyone agreed that it would probably not be a good idea for her to be there alone, especially after Carl died, who was basically the one who managed everything. Rachel, who then took on the responsibility of handling all of affairs, and the hurricane immediately following the death.
Essentially, just so I can make sure I understand your position. Your position was that, look, the reasonable explanation is she never really wanted to exclude Donald from the will to begin with. And
that was one reason. Yes, sorry.
Okay, I just wanted to clarify that was essentially what you're saying, the evidence, what your position was.
Yeah, that was one reason. The other reason was that she wanted to have the house divested out of the estate. And, you know, even though Mr. Kelton says that it's against her self-interest, and it was not listening to counsel or counsel's advice who prepared the will, we've all had clients who, when you explain to them what the benefits or the negatives are to doing something, people choose to do what they want based on what they feel their moral compass may say, or their feeling of responsibility or compelling interest in fixing maybe something in the past. This is all speculation from that standpoint as to why. But she did not want to.
One thing that was interesting, I thought, is I think I remember your client's testimony being, I think he answered a question. He was asked, why didn't she just revise the will? And I believe I remember your client saying something to the effect of, well, we couldn't get a lawyer that would do it because it didn't appear that she maybe didn't have capacity. Am I remembering that correct from the record?
What he did was he went and obtained a lawyer, Attorney Norman.
And and then the lawyer came and visited and then refused to do the will, correct?
Correct. He said that he didn't feel comfortable doing it, but gave no explanation.
Counsel, all I'm asking is about your client's answer to that question. Was your client's answer to the question that essentially that, well, she couldn't find a lawyer who would do it?
I don't know if that was the exact words, but he said that he went and obtained a lawyer who wouldn't do it. Whether he could find another lawyer, there was no evidence that he tried to get another lawyer or that another lawyer actually went to see Ms. Clokey.
Well, let's say for a minute that he did, that was his answer. Essentially, hey, the reason she didn't revise the will is because we couldn't find a lawyer who would do it. Isn't that kind of a double-edged sword? Doesn't that, how does that help your case instead of hurt it?
It doesn't help the case. I don't believe it hurts it. I believe it's a gentleman who, in his opinion, just made a statement in court. There was no testimony by any attorney that Ms. Clokey was ever incapacitated or that no will could be created or modified because of her lack of capacity. There's no evidence at all in the court record as to that at any point in time. Even after she did the deed in March of 2017, there was no action taken until the filing of the action in June, which was 3 months later. And even then, there was no affidavit signed by anyone, no mental evaluation that Ms. Clokey was incapacitated, even as far as June of 2019. And no evidence presented in court at any point in time that her level of dementia, or if there ever was a diagnosis of dementia, because no medical records were ever provided, no medical expert ever testified, whether or not she ever became incapacitated. She was an 80-plus-year-old woman who was forgetful. And, I have personal knowledge of that. I have two parents in their 80s who are forgetful. That doesn't mean that they don't know what they're doing or that they can't make decisions as to what they want to purchase or what they want to sell and what they want to give away. Even I've had conversations with them, even when they want to do things that I think are against their own interest, I allow them to do that. I don't stop them. It's their choice. As far as the reasonable explanation, I guess the court relied clearly on the testimony of all those who were present at the time of signing of the deed, the defendants, the Johns. There was also a notary who didn't testify, which could have been called into court to testify whether or not there was any type of undue influence or whether there was any kind of fear. The testimony clearly indicates from the Johns that although they've had multiple conversations prior to the deed, they were sure that that Ms. Clokey wanted to do this, and she wanted to do this on her own volition. And that's the reason why they did actually show up and witness the signing of the deed. There was no action taken after that, after it was known to everyone that this may have been a problem, until 3 months later, when it appeared that Ms. Clokey may be in her last few days. And at that point, the personal representative decided to file a lawsuit 3 months later. The court based the testimony of the defendants and Mr. and Mrs. John as a reasonable explanation to overcome the rebuttable presumption. The testimony of the Johns was that this is what she wanted to do, and she expressed this divesting of her homestead going back to October when she first offered it to Rachel, her adopted daughter. And so there was a clear intent for many months that this is what she wanted to do. Nowhere did the court indicate that it limited its analysis to the analysis of just overcoming the presumption. We know that there was no testimony that created an undue influence situation, but that the presumption occurred because of the relationship and the fact that Mr. Clokey did procure someone to create the deed. Margaret's intent to divest herself of the home was, like I said earlier, for approximately 6 months prior to the actual signing of the deed. In addition, there was a clear intent communicated to the Johns of her desire to do so. At this point, I don't find that the explanation, that the reasonable explanation to overcome the presumption isn't clear enough or isn't satisfactory to opposing counsel. The courts indicated that there was no sign at any point in time that she was incapacitated, and therefore she has the free will to do what she wants. She indicated she wanted to divest herself of the property. There was some testimony that Michael had maybe indicated that he was going to sell the property, even though opposing counsel says, yes, that was said by my client, but Michael Clokey never denied it. This trial basically, like the record shows, was indicated that we had 3 separate dates. There was an April 24th of 2019, where the first part of the case was presented, May 3rd, 2019, approximately 2 weeks later, and then closing arguments 2 weeks after that. So there were 3 attempts to present all of the evidence and the closing arguments to the court to indicate whether or not there was an undue influence. Opposing counsel, I mean, my understanding of the argument is that he doesn't claim that there was a lack of capacity. He just claims that there was a presumption that was raised. I agree. There was a presumption under the law that was raised. Now the question becomes whether or not there was a reasonable explanation. And I believe the testimony in the court file clearly indicates there was a clear intent. It was a desire of Ms. Clokey. It was not done within several days or several weeks of her desire to express. It was known to everyone that she wanted to get rid of the house and take it out of her name. It was also her desire in the testimony in the court record that she also wanted to spend nights at the house and that no one would let her do that alone. And so she felt that if she gave the house to Rachel and she denied it and it was given to Donald, then she would be able to do so. And in fact, the record shows that at some point in time that Mr. Clokey or his girlfriend said that they were together willing to buy out the interest of the home. And that didn't occur either, as far as that goes. So from this standpoint, I think the court's got it right. I think it's just a matter of Mr. Kelton asking the appellate court to say that the lower court didn't give an adequate explanation that was reasonable and what information was relied upon to determine that it was reasonable to his satisfaction. And that's why we're here.
Okay, thank you, counsel. All right, we'll let the clock reset. It looks like we have it there, 4 minutes and 13 seconds in rebuttal.
Thank you. I think, again, what's important to note here is that the testimony of the Johns is testimony that's relevant to whether or not there existed undue influence. But that's only after the presumption has then shifted back. Once it shifts one way, it's rebuttable and it shifts back. Then their testimony that, hey, we didn't see any undue influence becomes relevant. But undue influence, the nature of undue influence, as the Carpenter court stated, it happens behind closed doors. It's very hard to prove.
Isn't there at least two potential reasons in the evidence that might have been explanations for this? Number one, there was at least some testimony that that she never wanted to exclude Donald from the will, but that was her husband's desire.
That was.
Go ahead.
I know I interrupted you. Go ahead.
Well, and then the second one, of course, has already been discussed, which is that she didn't want the house sold. Why aren't those two enough here?
They're not supported by competent evidence. There's nothing. Donald was the only one that claimed.
Counsel, I thought we already established that Donald's testimony is competent evidence, or is it not? How is it not competent evidence?
He was estranged from her for 5 years. He was not part of the estate planning. He was not part of the meetings with Kobe. He wasn't privy to any of those conversations. And in fact, he specifically said, I did not take her back to her own attorney because I didn't want the attorney to talk her out of this. So he deprives her of counsel. He deprives her of somebody giving her advice and saying, look, we've talked about this before. Are you sure you want to do this? And so the idea that she somehow had some dispute with Donald or with her husband, late husband, about whether or not to include Donald, that there is nowhere else in the record. Kobe Finley testified very adamantly. There were very specific reasons. She had conversations with Mrs. Clokey, and they were very specific as to why Donald was not to be in the will. This idea that there was some ongoing dispute between Mr. Clokey and Mrs. Clokey just came out of thin air. But the attorney who actually prepared the will and then prepared a later codicil, the will itself is evidence that if she wanted to include Donald, she could have, because she actually chose to include Jennifer. Jennifer is the youngest of the children. She included her against what Mr. Clokey wanted. There was a dispute. It was about Jennifer. Mrs. Clokey said, I'm going to include Jennifer in my will. She was in the 2014 version. She was in the 2016 version. And only 2 months later did she change her mind because of a falling out separate, that she then went back to Attorney Finley and said, okay, now take Jennifer out. But she had the ability to stand up to Carl and do what she wanted to do in her will. They were not the same. The two wills that they signed in August of 2016 were not the same. So this idea that she wasn't able to put Donald in the will, it came out of thin air. It came from Donald, who admittedly had been estranged from them for 5 years. And again, the burden I think is important here, because using the Johns' testimony to provide a reasonable basis, it skips the middle step. The middle step is, we've already established there's undue influence. What you have to do to rebut that presumption is provide a reasonable explanation. That reasonable explanation cannot be the lack of undue influence. We've already established that. It's presumed at this point. There is undue influence. Provide us a reasonable explanation why somebody would divert from their longstanding estate plan given all the facts, why somebody was deprived of counsel, why you didn't notify any of the other family members on the day that you did it, why you solely added Lynette Hughes to the deed. He testified at trial. That was his idea. His mother did not ask for that. He put her on the deed himself. You have to explain all of these things. And if you provide a reasonable explanation, then the presumption then is rebutted and it shifts back. They did not do that. There is no explanation. I think that the law says that this case has to be overruled, and that it cannot be affirmed. It has to be overruled. The trial court's ruling is erroneous as a matter of law.
Thank you, counsel.
Thank you.
All right, nice job on both sides. And with that, this court is adjourned.
Thank you.
Thank you.